Okay, so I think we're going to get started. I think a programming note that the mics will be controlled by the AV folks, and so we don't have to keep pressing on and off. So I want to welcome everyone to the public hearing on the New York Voting Rights Act. It is Super Tuesday, and so there will be millions of people watching elections and cable vision networks later on tonight to be in tune with the results of elections across the country. But millions more are watching right now because we have our own Super Tuesday right here in Albany. But in all seriousness, I want to thank everyone for coming today. This is an incredibly important issue. We know that in 1965, the United States Congress passed what many would consider the strongest civil rights law in the history of this country. That was the Voting Rights Act. And we saw that in the wake of 1965's passage, that voter participation and registration rates went through the roof. But in 2013, the United States Supreme Court gutted the Voting Rights Act, and we saw the strongest portion of that act, Section 5, that dealt with preclearance, completely eviscerated. And so we feel a responsibility here in the state of New York to step up for our voters, to protect the franchise, to protect the right that protects all other rights. And it is our hope that today, in talking with the experts and the folks who are charged with administering our elections, that we can make the New York Voting Rights Act a reality and have New York continue its journey from worst to first. And so I think we are, just want to make sure I am joined by a co-sponsor of the bill, Senator May, who I would welcome to give any opening remarks if she'd like.
Thank you. I just want to thank Senator Myrie for his leadership on voting rights in general in New York State. It's been pretty exciting just in the last year and a couple months to see the progress that we've made here, and I think this is a really important step in the right direction. New York State doesn't seem like a state where these issues should be at the forefront, but voter suppression is real in this state, and we really were one of the worst states a year ago for voter participation, voter turnout, the feeling that voters had that they were welcome to both register and vote. And so we're changing that. We're working very hard to change that, and I think this is a really important step in that direction. And I look forward to hearing testimony, although I will be in and out today. Thanks.
Thank you, Senator May. And as a programming note, for those of you who come up to Albany on Tuesdays, you know that today is a very hectic day. I see we also have with us our chair of elections in the Assembly, Assemblymember Chuck Levine. You can't see him in the camera, but I assure you that he is here. So folks will be in and out, but it is not an indication of how important the issue is. And I suspect that I'll be joined by a significant amount of my colleagues throughout the hearing. So we are starting off with the State Board of Elections with Bob Brehm. I would be remiss if I didn't, again, thank you. We passed 53 amendments to the election law last year. We have given the Board of Elections a lot to do as a legislature, and you have done a pretty good job at implementing what this legislature has passed. So I want to thank you for that, and thank you for your service. Every testifier will have 5 minutes, and we will start when you are ready.
Well, good morning, Senator Myrie and Senator May. Thank you for the opportunity to speak today on the subject of the New York Voting Rights Act. Just in general, the State Board has not taken a position on the specific proposal, but my comments in general are in relation to the drafting of the bill. Joining me is Brian Quayle, our counsel at the State Board, one of our two counsels at the State Board, and we provided written testimony, and I'll highlight it and then save time for questions, certainly. But I think most importantly, securing, protecting, and making meaningful the fundamental right to vote is a governing imperative. As the Supreme Court rightly observed in 1964, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even more basic, are illusory if the right to vote is undermined. So certainly the right that guarantees all other rights is the right to vote. The legislation as proposed is certainly, establishes a lofty goal, a beacon to focus on, that the vote supplementing that federal position is quite important. Certainly in my time at the State Board, we have had a continuing dialogue with the Department of Justice, both during the period of time when we had pre-clearance and even after pre-clearance. We continue that dialogue on implementing various components that impact on federal elections. But I am somewhat concerned of the difference between levels of government and the fundamental difference that the legislature enacted after Watergate, which basically took election administration out of the hands of a single political authority and put it into a bipartisan authority. I think some of the examples throughout the country that are still alarming are where election administration is under a single authority. And I think we've seen where the disenfranchisement efforts have been greater in that model. And certainly, I appreciate the reference to the 53 pieces of legislation. It's important to note that we still have received no money on any of those proposals, except a very small amount. And the State Board continues to be chronically underfunded. Even with the executive proposal that we have today, we're almost 1.5 and change million dollars in a deficit position. It's very difficult to do the meaningful planning to implement the reforms that you enacted, which are in and of themselves proof that New York is on a path to enfranchising, not disenfranchising voters. And no one of those bills is a magic solution, but the mixture of them, I think, will really help to provide meaningful services to people across the spectrum. The other thing that I think also concerns is twofold. There are many resources, and the State Board is no different than many county boards, especially the small rural county boards. Over 40 of them are very small. They probably have 2 full-time employees, 2 part-time employees, and even their county IT support is small. So it's difficult for them to put together meaningful responses and plans to have to submit those for a process that is time-consuming. And it also, I mentioned this bill is effective immediately with certain impacts. Many of those 53 bills were effective immediately. The LLC loophole gave us a little window that gave me 7 days to implement. But it puts off those implementation dates until this step can happen also. But the fundamental difference at the federal level, they cannot legislate. They can only review proposals and make declarations that they might impact negatively on enfranchisement. But you, the legislature, make the laws. It could be more efficient to upfront a goal to make sure they're implemented better at the upfront than perhaps a process on the flip side. And the other that it does, it allows both an attorney general, not necessarily this attorney general, and any judge that is looking at this, to vacate a current statute without a standard in the language as to what would be a sufficient finding. So we could have a patchwork of solutions that are out there. The benefit of elections is uniformity, to know that people are treated fairly and equally from one jurisdiction to the other, especially for those, especially in a Senate district or those jurisdictions that go to multiple counties. You want to know that there's a uniform way that we're applying the election for those votes. So those are certainly some of the challenges, whether they're addressed in a drafting of the bill or just a clearer understanding of their impact. But there will be an impact on county boards of elections to make plans and to filter all of the planning process. And it's either, so your goal may either work this way or perhaps just making a clear direction of how to implement the bill in the first place so we never get to this step might also be a good incentive.
Great, thank you. Do you have any?
Only one question. So thank you for your testimony, and yeah, I echo what my colleague said about we've put a lot on your plate this year. Do you have an estimate of what this implementation of this would cost, or what additional costs you might?
Well, it's hard to factor that because how many years in a row will we get 53 chapters? I hope one. It's because it does, every one of those laws is different. But if you look at pre-clearance for polling sites, there are often changes to polling sites. So I don't have a real number yet, but certainly it will depend on the procedure put in place by the Attorney General to submit plans, and then what is that process. It could take as long as 60 days. There are extensions that are provided for. There were times with the Department of Justice that we would go longer than short, but on many of the issues when we were rolling out the new voting equipment at the behest of a federal judge, some of those implementation, we got pre-clearance really quickly. And when we had Hurricane Sandy, we got pre-clearance from the Justice Department within hours. So it depends on what we're doing and the continuing dialogue we have with the entity that is reviewing it. That dialogue and an understanding of the procedures really is I think, the basis of being able to answer that question. If you have a clear path to follow, you factor that into your planning in the beginning. If it's unknown where that is going, then it's hard to know that if there's a judge somewhere that has a different view than a judge somewhere else, how do you prepare to meet their needs? It's hard to anticipate.
Thank you.
Thank you, Senator May. I do have a number of questions, and I would agree with you wholeheartedly that the funding necessary for the Board of Elections is an issue for which this legislature should be fighting for, we will be fighting for, because we cannot be imposing changes that we also don't give the resources for. So we will continue to advocate for that. There have been some gaps in the executive budget on that front, and I think we can anticipate that the legislature will be fighting to fill those gaps. Can you speak you mentioned a number of concerns and challenges, and I'm glad that we're able to have this discussion in this hearing. Can you speak to what your compliance apparatus was like with Section 5 on the federal level pre-2013, and whether you had the same concerns about the imposition on the local boards or the state board?
When we had, I'll go back to when I first started at the board. I started in February of 2006. 1 week later, the Justice Department came to visit us on New York State's implementation of the Help America Vote Act. They left in 2013 when the law changed. When we compare New York to our colleagues throughout the country, when the Justice Department would visit them and we were at a national conference and we would talk about our experiences, they were always a little fearful when the Justice Department came. Our approach is, it's never a fearful, it's a dialogue, it's a conversation. We're never so right in our position that we're afraid to talk about it. Certainly more ears and eyes on a process help to discuss and think of things we didn't, maybe a perspective we didn't look at originally. But some of those conversations I think might be better up front to build that structure of dialogue up front. I mean, we follow the state process for public hearings on regulations, et cetera, to post them and publish them. We try to put them on our website. It's hard to reach out to underserved communities when we don't have any resources from the day-to-day for the board to answer the phone. At our conference on early voting in November, one of your colleagues had asked, who did we reach out to on the communication plan? It pained me to say no one, because we had no money to even, none of the resources and responsibility on the bill came to the state board. Not that we couldn't have done it, but we didn't have any resources to do all the other things you asked us to do. We had no ability to do the extra. So that's, the budget, to me, is the biggest barrier to us complying with the rule or this proposal. If the budget proposal had to go through pre-clearance, then maybe I could be more confident that I could stand here today and tell you that we could do it. Not that it's just money. I think the mindset that we've always had, that we have to discuss it anyway, it's not one philosophy. I go across the hall and talk to my colleague. We don't agree on everything. We don't disagree on everything either. We agree on more than we disagree. My colleague next will speak to hoping that this could be a process that would break ties and boards. I'm not confident that the way it's written that it has that ability. I think it has more ability, especially with the court intervention, the way it's worded, to really fragmentize policy. And from my perspective, I think uniformity is a very good goal from one end of the state to the other. So that does concern me. I think there are ways you could probably work within the drafting of the bill to address those.
Thank you. And we have a safe harbor provision in the bill that seeks to prevent this from going to the courts and from litigation, and to protect taxpayer dollars. And the goal is to give jurisdictions and local boards the opportunity to correct any violations or alleged violations before litigation. And so I'm hoping if you could speak to that, because I think it's a valid concern that we try to address through the safe harbor provision.
Yes, the safe harbor provision of the bill does seek to do that, but it may invite some additional issues. One of which is that it would allow, in the process of correcting a problem, to permit the Civil Rights Bureau and the Attorney General's office to essentially abrogate any local or state law for the purpose of remedying the violation. And the remedy part is of no concern. The issue is when you have no deference shown to either the state or the local law, you invite the patchwork quilt of election administration from to occur without any finding of necessity. So one of the things that was mentioned in the written testimony is that while there may be instances where it is necessary to abrogate a state or local law that is in and of itself the problem, there should be something in the legislation that would prefer adequate remedies that fit within the parameters of existing law, both state and local. I mean, after all, it is the legislature, when you made the 52 changes to the statute, your expectation is that the people who you tasked with implementing that, various boards of elections around the state, would in fact do that. I don't think the legislature is anticipating that a bureaucracy within the Attorney General's office could abrogate those laws for no particular showing other than they just want to in order to remedy something. So the necessity component in the remedy, I think is something that you may want to look at with the draft.
Okay, I appreciate that. I will note that we've been joined by Senator Brad Hoylman. Yep. And so I think we could go back and forth on that. We know that there are other states that have a State Voting Rights Act, not the least of which is California, who have been able, I think there are studies that suggest that the stated goal to, at least part of the stated goal to increase participation and to have voters elected officials that look like them, that has been demonstrated by the California Voting Rights Act. It is a large jurisdiction with many boards of elections, and I'm wondering if there are any material differences between California and New York that you think speaks to your point of this perhaps creating a patchwork.
Well, in particular, I think it's important to look at, I mean, in terms of what California is doing, in terms of what New York would do. I mean, one of the things to look at is over time, what's the overall impact on the landscape. I think a couple of the things that the bill really aims at doing in New York is, for example, I mean, the sub judice is that there are a lot of problems potentially with at-large formulations, and among the possibilities would be actually changing the state law to, under certain circumstances or in general, just saying that if your jurisdiction is over a certain size, you won't have at-large representation, or amending state law to permit or even require, in certain instances, some of the remedies that are spoken to in the bill, like ranked choice voting or limited voting or cumulative voting, and making those policy decisions. Because what you can envision, whether it's in California or it's in New York, over time, the determination as to whether or not a particular jurisdiction will use a particular method of voting or alter state election laws or even election days in certain instances, which certainly is a patchwork, would be basically up to a bureaucracy in the state attorney general's office, and it would be a significant power that the legislature is passing off. And so the issue is how best to effectuate the remedies.
Thank you. You mentioned in your written testimony about the portion of the bill requiring new data gathering and dissemination, and I can correct me if I'm wrong. You make the argument that this is something that should be done within the Board of Elections and not as the bill proposed in SUNY, and I'm hoping that you can speak to why you believe that is.
If I can. So one of the interesting things to look at with respect to that question is sort of the federal analog, which is you have the Census Bureau, the Department of Commerce, sort of creates the data, and then currently the Department of Justice takes a look at every county in the country and through a rules posting determines what language services are required in each county in the entire country. It's a largely ministerial act. This bill clearly goes much further. One of the things that it does, obviously, is it lowers the thresholds for language accessibility services. It basically halves them. Instead of looking at just political subdivisions as counties, the way I read the bill, it requires an analysis of every political subdivision, a school district in any district, and where you meet the criteria in any political subdivision, you have to require the services. Those are ministerial calculations. And the data set is there, and there'd be some resources involved, but you could tell the State Board of Elections to calculate that. In addition, the bill goes much further in requiring a significant overlay of data and analysis associated with not just the census data, but putting that together with election results and what I would call specifically voter demographics. Those commands could definitely be done within whatever organ of government the Senate says has to do it, and whatever criteria that you have for the director or person who's in charge of that. I know this bill specifies postdoctoral experience on the part of the director of what would be a new SUNY bureaucracy to accomplish that. You could mandate that within the State Board of Elections and determine the criteria that you want and for that purpose. So irrespective of exactly what the correct policy is, if you want a data clearinghouse, the best place to put it is as close to where the data currently is, and the people who are best suited to prepare it, particularly with the ministerial aspects of it. And so it would seem that would make a lot more sense to have that rest with the State Board of Elections.
Yeah,
But that's a policy choice.
I mean, in addition to that, it's just the nature of where we have many entities administering elections without adequate resources and And certainly during the budget season, the balance of all of the state's demands and how to fund them are there. But if we have that skill set at the board with funding, whatever extra funding would make that available, it certainly would be helpful in the planning process too, to be able to have that interaction. It's more difficult if they're silos in different agencies that really can't do long-term forecasting and planning easily together, because perhaps neither of them have enough resources, but somehow synergy in one entity, I think would be better. Could be better. I don't know if it would be, but it could be.
Thank you. Senator Brad Holman.
Thank you. Thank you, Senator Myrie, and thank you for your leadership in introducing this, I would say, groundbreaking piece of legislation to protect the franchise in the state of New York. And really, while it's revolutionary in New York, it's something that other states have done, particularly in light of the fact that the Federal Voting Rights Act has been eviscerated by the current federal administration and courts apparently kowtowing to their wishes. On that point, I wanted to ask you, what changes have you seen as election administrators since the recent court decisions about the Federal Voting Rights Act? What are you witnessing in terms of your, or experiencing in terms of compliance with the federal government? Now that the Federal Voting Rights Act and the issue of pre-clearance is basically dormant at the moment, what does that mean for you on a practical basis?
Well, certainly the conversation with the Department of Justice implementing any law, we would get pre-clearance for every chapter law that was adopted. Certainly that would have been a challenge last year. But it involves a conversation with the Department of Justice. I think an example.
And so now you don't have to do that.
Well, it's not that we don't hear from the Department of Justice. We continue to have a conversation with Justice over the voter registration systems, the voting equipment, certainly our implementation of the Military and Overseas Voter Empowerment Act, areas where we had a consent decree with the department over various issues, mostly the MOVE Act. But what do I see since then? An example was the voter issues that happened in Brooklyn. The Department of Justice took one position in New York and the exact opposite position in a sister state in the Midwest. That was a level of confusion that was kind of hard to see out of the same department, that said it's a violation of federal law here for Brooklyn to do it one way, but the exact opposite in the other state. So there had been a little confusion coming out of the Justice Department in areas like that. So I don't know if they reinstated that level of conversation. We have always, I think, enjoyed a dialogue with the professional staff at the Department of Justice during that period of time we were doing pre-clearance. Many of those same individuals are still there that we worked with and we continue to talk to. So I want to say, it's been a positive situation for, I think, New York State and for our interaction. How would we have rolled out this many laws so quickly if we had to do it? Would have probably been a nightmare for us, because it was hard to roll out this many changes in general. But pre-clearance on all of the moving parts of early voting really would have been a challenge. There was a tremendous benefit to us to have rolled out that pilot last year. It's so that we can work out what we need to fix for this year at a period of time when it's a low turnout. But to have done that with all the moving parts, certainly I think, change is always a challenge. It's hard to look at how we would do 50 laws if this were in effect last year. But if this were in effect maybe 3 or 4 years earlier, probably last year, we could have made it more smooth, because all of the early implementation would have been fine. So I think the effect of the bill, the effective date of the bill, where it's effective immediately, but perhaps the enforcement or the other issues you put out a few years, I think is helpful for our understanding of we're in this together, how do we implement this, and maybe we make some tweaks along the way.
The Department of Justice had not objected to a New York State preclearance application or an application on the part of any entity within New York State since 1999. There's a fantastic webpage on the Department of Justice website, and by each state it lists all the preclearance applications that have been denied. And it is telling when you click into each of those states and you see what's there, you can see the power of what preclearance did and how important it was. And in certain places, far more so than others. It is also important to understand, I think a lot of people conflate preclearance issues with other substantive aspects of federal law that are very much still in force and applicable. In fact, all the substantive provisions are. It's just the preclearance provision is not, unfortunately. We also have in New York State, through the Civil Rights Bureau at the Attorney General's office and through robust private litigation, a number of avenues to enforce and ensure that that those laws have meaning in this great state.
Thank you.
Thank you. I would note that, and I appreciate the feedback and answers to Senator Hoylman's questions. You know, part of the Supreme Court's rationale for gutting Section 5 was that we are in different times, and the suppression looks different than it did in 1965, and that it worked, and so we can remove it. And I believe it was one of the justices' response to that was, you don't throw away your umbrella because you're not getting wet in the rain. And so the notion that our preclearance applications have not been denied, I think actually speaks to why we would need to, as a state, step in the absence of federal action. And I would also note on early voting that part of our concern and why we feel this is still necessary is that we saw the placing of certain early voting sites that we believe disenfranchised black voters here in the state of New York. And so while it may have delayed the implementation, that may have, I think it is a worthy delay in order to protect the franchise. But I know we have a lot more folks, a lot more witnesses here today, and I want to be respectful of people's time. I appreciate your testimony. We will continue to have the discussion as the bill progresses, but I thank you very, very much for your time.
Thank you very much.
Next up, we have Dustin Zarni, Elections Commissioner for Onondaga County.
Thank you, Senator. And I'd like to thank the committee and the New York State Senate Elections Committee for holding this important hearing today on the proposed New York Voting Rights Act. I believe this is an important piece of legislation. And while I share some of my colleagues' trepidation on how it's going to affect local boards, I am generally in favor of this. I need to point out that I am also the Democratic Caucus Chair for the New York State Elections Commissioner Association, and neither the New York State Elections Commissioner Association or my caucus has taken an official position on this piece of legislation. But I am here today to talk about what I believe was a detrimental decision by the United States Supreme Court to eliminate the preclearance section of the Federal Voting Rights Act, and why I understand the wish for New York State to implement its own piece of legislation. I've submitted written testimony, which I will highlight so we can get to any questions, and I know we have a long list of speakers that want to speak today, and it is Tuesday in New York State Senate, so everybody's very busy. I also, before I begin, will also point out the need for funding for any piece of legislation that is passed by the legislature. The state board is a tremendous resource for all of our 62 counties of local election boards, and their funding levels that are in the current executive budget for their current mandate is not enough. And we are asking them to shoulder the burden on online voter registration and automatic, hopefully, voter registration in the near future, but also the campaign finance portion of our enforcement is all burdened by the State Board of Elections now. And they are in need of funding, not just for this piece of legislation, but for every piece of legislation that has been passed, because they shoulder the burden for a lot of our local counties. As Executive Director Brem said, a lot of our local county boards don't have a lot of staff. The smaller boards may have as little as 4 staff and only 2 full-timers. A board like myself, which has 300,000 registered voters, we only have 28 staff. So, I'm sorry, we only have, my office is gonna get very mad at me. We only actually have around 14 staff, and then we have some part-timers that come in around election to help out as well. So, putting the burden on local boards to shoulder a lot of this, a lot of times we lean on the state board to give us guidance, to give us standard operating procedures, to come up with resources for us to be able to plug into. So making sure they are properly funded and funded to the level that will exceed their mandate is important. I am generally in agreement with this legislation because I believe it sets up a framework where we can adequately give avenues for voting rights activists and boards of elections that may be in disagreement to have an arbitrator that is maybe not the court system, or a streamlined path through the court system that could eliminate costs and money. Right now, which I am a proponent of, the current New York State electoral system, the way we handle and administer elections is, I think, a model for the rest of the country. Our bipartisan commissioners have to come to agreement, and most of the time are able to put ideology aside to benefit the will and need of the voters. But there are times where they are in disagreement, or sometimes they come up with something that is, not acceptable to the voters that they serve. And having a system in place that could give a better and more streamlined approach to how to arbitrate those decisions is important. We did see with early voting last year, some counties went well above the minimum, some counties did just the minimum. We saw that, issues with counties keeping early voting centers outside of urban voting centers. Right now, we have a deadline coming up on March 15th where we are going to be setting our early voting sites for the presidential election. Most likely, those will be the early voting sites for the general election in most cases, in most counties. There is no clear plan in place for if there is a disagreement at the board or a disagreement amongst the populace. And having a set of guidelines, and perhaps the Attorney General as an arbitrator before it goes to court, before it goes to judges that may not necessarily know election law, may not have studied this, may not have the time. We've had court cases that go well beyond their minimums. I had a court case in Onondaga County in 2018 that delayed the printing of my absentee ballots for weeks while a judge waited for a law clerk who was sick to come back and write a decision. And even though they were supposed to write that decision within 1 day of hearing, of the hearing, because it was so late in the calendar, that judge decided not to do that, and that delayed and cost our board a lot of money. And it was in a dispute that our board had no part in, but it was because it was a dispute that other parties were a part of. So it's something that, the the new calendar makes some of these things go away, but I would like to explore this as this law evolves and as this law is discussed. I do want to stress that while the law is effective immediately, some of the enforcement actions are several years down the road. And while we look at that, if this law is to be passed, is having a cooperative, a cooperative discussion with the local boards, with the state board, with the New York City Board of Elections, on how they could work with the Attorney General or whatever authorized body to help bring in a streamlined system so that the burden on the local board is as little as possible. But I've submitted my written testimony, and I'm willing to take any questions on this.
Thank you, Dustin, and thank you for your continued working relationship with the legislature. I'm going to thank you for the work that you do in implementing the changes that we've made. I'm hoping you can speak to, you mentioned in your oral testimony, but also in your written testimony, the notion of disagreement with commissioners and how you feel that the Voting Rights Act, the New York Voting Rights Act, might assist in that process. So I'm hoping you can speak to that. But before that, I would like to recognize that we've been joined by Senator John Liu and rejoined by Senator May.
Senator May. So currently, if there is a disagreement amongst commissioners, there are some statutes where if commissioners disagree on counting a ballot or counting a petition, then the tie goes to the runner, so to speak. It's assumed valid. So if there's not agreement by both commissioners to throw something off, then it's assumed valid, and it's up to the parties to go to court to get that overturned. But where there is disagreement on polling places, early voting places, there isn't really a great guidance of where to go. Now, I have to say, I believe in the bipartisan elections commission structure, because most of the time we do come to agreement and we are able to come to some kind of agreement. But we also do serve the parties that nominate us and the legislatures that appoint us as well, and sometimes those outside factors come into play. And without a clear path of how to resolve those types of disagreements, sometimes solutions come about that may not necessarily be the best for voters. There is great amount of pressure to resolve that at the board level. And I agree with that pressure. It should be if it can be. But sometimes it can't be. And sometimes we need an outside party. And there is a fear of costing our host counties money by fighting it in court. Or a fear of even a path to doing that before statutory deadlines come about that will disenfranchise our voters. I mean, my local board has to decide. We're meeting tomorrow to decide on our early voting sites for presidential election. I believe we have an agreement in place, so that's good. But if we did not, then I would have to institute a lawsuit before March 15th against my counterpart to change or move sites around or whatever. And that is a hard burden on a local board to institute, especially many of us are not lawyers ourselves. We then would have to go to our county law department. Our county law department is supposed to serve both commissioners, so then they have to decide, whether they're going to get outside attorneys. This is an arduous process to go through that. So it's reserved for the most grave of situations. But if there was a different process in place, and I'm not so sure that the current legislation actually provides that, and maybe that's something that could be worked in to another form of this legislation or a chapter amendment, because there is no path in the current legislation for if commissioners disagree. But setting up some kind of expediency within the judiciary or an outside body like the Attorney General to, on some of these issues, could, at least provide a framework in the future for addressing that type of issue.
Hi, Dustin.
Hi,
Sorry I
Senator.
missed your testimony, but I had one question on your written testimony where you say that this Voting Rights Act could serve as an avenue for voters to properly address decisions made by elections boards they disagree with in a cost-effective and efficient manner. Can you talk about what you mean by cost-effective and efficient there?
Well, anytime any decision is made by the board, the only way to overturn that at this point is to go to court. And that's just costly for many public advocates groups, for many campaigns, for whatever, for the voters in general. And it's also a labyrinth of a process many times that people don't understand. And then, of course, many times once they get through the process, they've missed serving deadlines or whatever, and their cases aren't even decided on the merits, they're decided on arbitrary rules. If there was a pre-clearance section, for one, many of these decisions would be handled before it got to that point. The safe harbor provision that was mentioned earlier, if perfected as what the state board has suggested, could serve to do that as well, so we could prevent some of this legislation or some of this litigation. But also, again, if there is a set of guidance of what, if there's precedent set with other cases throughout the county in some of these things, some of these arbitrations or some of these streamlined court cases, then that could also prevent bad decisions in the future, because we would have more guidance and more precedent set, and we'll be able to have that on our internal deliberations as well.
Thank you.
Dustin, thank you very much for your
Thank you.
testimony. So next up, we are going to have a panel, a panel of two. Round of applause. A panel of two, and that will be Michael Pernick of Paul Weiss and Perry Grossman, Senior Staff Attorney, the Voting Rights Project at NYCLU. And if any of you know the New York Civil Liberties Union. If any of you know Perry, you know this will be a very subdued testimony. So we're going to give each of you 5 minutes apiece. You can split that up however you'd like. You can defer to each other, but you will have 10 minutes total, and you can split that up however you like.
Thank you, Chair Myrie, members of the State Senate Elections Committee, for the opportunity to testify today. My name is Michael Pernick. I'm a litigator at Paul Weiss. I'm appearing today on behalf of the New York Civil Liberties Union. My legal practice includes representing parties in voting rights and election law cases, including cases brought under the Federal Voting Rights Act. And I'd like to focus my testimony today on the voter suppression and vote dilution causes of action that are laid out in Section 17-206 of the bill. The voter suppression right of action addresses voting practices by political subdivisions that would deny or abridge the right of racial or ethnic minority groups to participate in the political process. For example, this provision could be used, as many have referenced, to prevent a board of elections from placing polling sites in communities that are accessible to white neighborhoods but not neighborhoods of color. It could be used to prevent boards of elections from purging voters in a manner that disproportionately affects voters of color. So these are the sorts of tools that are available under this bill that would be extremely helpful to minority communities. The vote dilution right of action addresses methods of election that dilute the votes of racial or ethnic minority groups. So, for example, as has been referenced, if there's a minority community that uses an at-large structure for its local elections, or rather a jurisdiction that uses an at-large structure for its local elections, and there's a substantial minority community that's been unable to elect candidates of their choice, they would be able to use this right of action to actually have a voice in their local government. Similarly, if there's a political subdivision, a municipality that draws lines in a particular way that dilute the rights to vote. So, for instance, if you have a minority community that's pretty substantial, but it's split into 4 county legislative districts, and they're unable to get any representation at the county level, that's the sort of racial gerrymandering that could be attacked under this right of action. Now, to be clear, these sorts of claims can be brought under Section 2 of the Federal Voting Rights Act, and we've seen plenty of that litigation here in New York State. But the Federal Voting Rights Act is a difficult piece of legislation. It's a difficult bill to sue under because it includes a patchwork of elements that have been layered on by decades of federal law. And the result that we have today is a very complex cause of action, very burdensome for parties to litigate on both sides. In order to bring one of these cases, you need a team of specialized lawyers, you need to hire expert witnesses, and to defend these cases, jurisdictions need the same. That being said, there are many municipalities across New York State that have been sued under Section 2 of the Federal Voting Rights Act. Counties such as Albany, Suffolk, Niagara, Orange, towns, Babylon, Islip, Hempstead, cities such as Niagara Falls, Buffalo, New Rochelle, villages such as Port Chester, and school districts such as Mount Vernon and East Ramapo. These cases involved years of litigation, cost taxpayers millions and millions of dollars in legal fees. For example, the vote dilution case that resulted in the town of Hempstead transitioning from an at-large structure to district-based elections took over 12 years to resolve due to the complexities in that litigation. In a recent case, it was just reported that a defendant jurisdiction would be spending over $6 million in legal fees and taxpayer dollars to defend one of these cases brought under the Federal Voting Rights Act. The NYVRA is important for many reasons, not least of which is that it fixes these problems in litigation under these causes of action brought under current federal law. It sets forth clear and predictable standards for the voter suppression and vote dilution causes of action. And it would eliminate the unnecessary burdens that are imposed by federal law on litigants on both sides. It would make it easier to address violations and dramatically reduce the cost and the burden of litigating these cases. I also want to say a word about the notice and safe harbor provision, which has been discussed somewhat in some of the other testimony, because it's a particularly important part of the bill. It creates a new mechanism for parties to resolve voter suppression and vote dilution claims without having to go to court. Now, here's how it would work. A plaintiff or a prospective plaintiff would send a letter to the jurisdiction. They'd be required to send a letter to the jurisdiction before they would be allowed to initiate litigation. And then the jurisdiction would have 50 days to just take initial steps towards resolving the potential violation. And if they do take those initial steps, they'll be granted extensions and they can have more time to try to resolve the issue before they have to go to court. This provision will prevent unnecessary litigation. It'll save a significant amount of taxpayer dollars. The provision is also important because it resolves a difficulty with litigating these cases that is somewhat unique to New York State. In other states, municipalities that are sued under the Federal Voting Rights Act often have sufficient home rule authority to resolve violations on their own without the need for a court to intervene. So this sort of mechanism is less important in some of those other states. But that's frequently not the state here in New York. For example, if you look at Section 85 of the town law, it would prevent a town that's sued over its at-large structure from unilaterally transitioning to a district-based election or some other remedy in order to address its issues. Similar restrictions exist in state law and municipal charters across the state, which make it impossible for jurisdictions to resolve violations on their own in many of these cases. So as a result, municipalities that are sued are put between a rock and a hard place. They can either litigate the claim and expend millions of taxpayer dollars in all of the expert costs and attorney fees, or they can accept that there's a violation of the Voting Rights Act, which has external consequences for the jurisdiction to stipulate to a violation of federal law. So it's really a tough decision that we put municipalities in. This provision solves those issues because it creates a mechanism for municipalities to solve violations, and it does have a standard. It has a clear standard that's laid out in the law itself. So I'll stop there, but I'm happy to answer any questions and turn it over to Perry.
So thank you very much, Senator Myrie, Senator May, Senator Liu. Very good to see you. I wrote 18 pages of written remarks. I hope you'll read them. They are, I would call them my comprehensive thoughts on the law, except I could probably write 300 pages on this law and not be done. Needless to say, I think it is a fantastic law in every respect. I would say that it's life's work, except it's not life's work. It is the collective wisdom of hundreds of years of work from all over the country by voting rights advocates, right? People who have been practicing, hundreds, people who have been practicing voting rights law for decades, pouring their wisdom into this law to try and figure out best practices and apply them here in a state where we can actually get things done, right? If you're concerned about what's going on in Alabama, if you're concerned about what's going on in Kentucky, Tennessee, Texas, do something better here, right? Let's push the envelope in the right direction against all of the states that are pushing the envelope in the wrong direction. I want to just breeze briefly through the provisions of the law and why I think they're all incredibly important. I want to dwell on preclearance just a little bit, because I'm a little bit annoyed by some of the remarks that have been made suggesting that preclearance is a burden, and I'd like to offer a little bit of testimony from someone other than myself, the current governor of the state of New York, who in 2009 wrote a brief in support of preclearance at the Supreme Court. So we'll make sure to get that view into the mix as well. The first thing that's important is the law institutes what's called a democracy canon, right? The idea that we should interpret the election law in ways that allow for votes to get counted by qualified voters. Right now, there is too much effort, too much game playing to keep people who are entitled to cast ballots, entitled to register to vote, away from that process. The law should be interpreted to make sure that people who are eligible to vote are able to vote, right? Mike just spent a great deal of time, and by the way, I gotta make a special thanks to Mike. I've never had my own lawyer before. Mike is an excellent one. He worked really, really hard on putting together our thoughts on this, and I wanna really give a special thanks to him. I'm coming up today in the middle of trial, right? I took a day off trial. My co-counsel is handling it. There's a witness on the stand right now who's being cross-examined. That trial is 3 years in the making. It has cost us millions of dollars to build the case. The school district that we're fighting, the East Ramapo Central School District, has spent probably in the neighborhood of $5 to $6 million fighting this. That's money that could be spent on teachers, it's money that could be spent on programs, it's money that could be spent on social workers and guidance counselors and educating children. But because we let jurisdictions fight nonstop with whatever lawyers they want, paying whatever legal fees they think necessary to defend their own power, we are letting taxpayer dollars go down the drain by not having a more efficient system in place. And so, to echo everything Mike said, we are watching a bad system all the time. And as the General Counsel of the State Board of Elections noted, yes, the entire Federal Voting Rights Act was not gutted by Shelby County. But Section 2, which is sort of the main portion of the law, which allows us to bring these suits, puts such a heavy thumb on the scale of jurisdictions and is so expensive to litigate. It's not that we don't have that many Voting Rights Act violations in New York. It's that we only have the millions of dollars and lawyers in place to litigate a couple of these cases at a time. So having a much more streamlined, much more effective process in place for bringing those suits is important. In California, it's been effective, and we can expand upon what they've done there. I think Section 3 of the law, which creates the statewide database, is maybe the best and most important thing because it adds transparency to a bad process. Right now, if you wanted to go get election information from most of the jurisdictions in New York, which mostly run their own elections, we're talking about school districts, villages, special purpose entities, you'd have to send about 2,000 foils because they're all holding their own elections data. The State Board of Elections is not the repository for very much. The county boards of elections aren't even a repository for very much. We need a central repository of data to understand what elections look like in New York State and to allow the boards of elections, to allow those school districts, to allow those villages access to the data to create best practices. We're not doing that now, and we should be. We should be providing the foundation for data-driven decision-making to enfranchise people and provide equitable access to the franchise. Section 4, language access. We have amazing language diversity in New York State, and the Federal Voting Rights Act does not recognize that adequately. I think we have a senator who represents at least part of Queens on the dais here, and Queens is horribly under-recognized in terms of the amount of language diversity and what election assistance should be provided to voters. We should have the data available to disaggregate and fully understand what languages the voters are speaking and to provide them the assistance they need where it's required. We should have academics, people who have real facility and understanding with this data and what it means working on it. Putting it in the hands of the State Board of Elections, which is barely able to manage the limited amount of data it has, much of which is due to its own lack of funding, and I recognize that and appreciate that, but we need professionals with experience on how to work with demographic and elections data. I think SUNY's the right home for that. I think the law does well by it. Pre-clearance. There is no more effective civil rights law in U.S. history than Section 5 of the Federal Voting Rights Act. It is the crown jewel of civil rights law as we know it, and it has not only stopped discriminating jurisdictions from implementing bad practices, here in New York, I think it has forced us to make much better choices. And I'd like to just put into the record a couple points, because there was some concern about the cost. And this is from the State of New York's brief in support of the constitutionality of Section 5. The name Andrew M. Cuomo, Attorney General, appears on this brief. It says, the preclearance requirements of Section 5 do not impose undue costs on covered jurisdictions. Administrative preclearance is expeditious and cost-effective. The process is neither difficult nor complicated. Rather, Section 5 preclearance is one of the most streamlined administrative processes within the federal government. Most preclearance submissions can be completed within a relatively short period of time. Moreover, even with respect to complicated submissions, such as redistricting and annexation, the amount of work necessary to prepare the submission is but a small fraction of the time required to make the election law change in the first place. Preclearance is going to help make our election administrators make better decisions on the front end. It will help the elections committee here make better decisions on the front end, because instead of having to worry about researching the impact of laws all the way on the back end, if we do it on the front end, we're going to save time. We're going to be able to implement new election changes quickly and expeditiously, and with the confidence that they're not hurting minority voters. Finally, just to clean up the sort of the back end of the law, voter intimidation is something that we are seeing in a more widespread way. The Trump campaign since 2016 and 2015 has made it obvious that it's an important strategy of theirs. We have seen, frankly, Republicans across the country and right here in New York engage in tactics intimidating and deceiving in order to keep voters, especially minority voters, from the poll. Right now, we do not have a state law provision that would allow voters to sue over that and to make sure that when deceptive ads or threats, like baseless threats to send DMV records to ICE that contain voter registration information, when those sorts of baseless and ridiculous threats are made, that there are remedies available, such as keeping polling places open longer, requiring jurisdictions to engage in public education campaigns, and anything else that would help remedy these deceptive and intimidating practices. So I thank you so much, Senator Myrie, for introducing this bill. I appreciate you, Senator May and Senator Lieu, for sitting through one of my typical rants, and for Michael for all of the work he's done on this. And any question you or any of your colleagues ever have about this law, it would be my pleasure to answer it.
Great. Thank you both very much. We're going to start with Senator Lieu.
Thank you, Mr. Chairman, for holding this hearing. And I appreciate the two of you for spending your time with us today. I know it's not easy, but nonetheless, these are issues that are very important. Chairman Myrie has taken it upon himself to change our entire democratic process in the state of New York and by extension far beyond. But the two of you have had some really important input, apart from our commissioners who have testified earlier. My main question to the both of you, because you both alluded to it in your testimony, is that we are very cognizant of the fact that we have redistricting coming up in the aftermath of the census. And you both mentioned things about redistricting that might be affected, I think beneficially or positively, by if we were to pass the New York Voting Rights Act. Can you talk a little bit about what some of the direct impacts would be of this bill on that redistricting process?
Thank you, Senator Lieu, for that question. So the first sort of throat-clearing point, the pre-clearance regime would only apply to municipalities and jurisdictions that fall under a formula. So the statewide...
fall under what?
Fall under a formula set forth... This one? Fall under a formula set forth in the bill. So the statewide redistricting plans would not fall under pre-clearance. The one part of the bill that could affect the pre-clearance, the statewide maps for the state Senate, the state Assembly, would be the vote dilution claim. So this would make it easier and more streamlined to bring a claim that has the effect of diluting minority votes. So if the map is drawn in such a way that cracks or packs minority communities, that doesn't respect minority communities of interest, right now, the only federal law that's really available to address that issue is Section 2 of the Voting Rights Act. You can also bring a claim under the Equal Protection Clause in certain circumstances. Those cases are complicated. They're difficult to predict. The parties don't really know how they'll turn out until you go through the process. They're very expensive and they take a very long time. This will give parties clarity if there are maps that are drawn that do have a dilutive effect on certain communities. If the maps crack communities in ways that make it more difficult for minority or ethnic groups to come together and elect candidates of their choice. So there are some other complications in federal law that this streamlines that could be important both for challenges to the statewide maps as well as challenges to maps drawn by municipalities. For example, this law doesn't allow jurisdictions to argue that different minority subgroups might not actually be in alignment and defeat claims using those sorts of arguments. This law doesn't allow jurisdictions to argue that partisan explanations are the real reason why voting patterns are exhibited in the way in which they look, and race doesn't provide a suitable explanation. So the upshot of all of this, the claims would be easier to bring, they would be more predictable, they would be more streamlined, they wouldn't cost as much, and you'd be able to obtain resolution on a faster timeline than you would if your only tool is Section 2 of the Voting Rights Act.
So I'll add just a couple things. The first is, I don't think this is necessarily going to lead to a rash of redistricting litigation. What I do think is that the specter of the law is going to make people behave themselves in the redistricting process, right? If you have strong tools to correct racial gerrymandering, people are less likely to engage in racial gerrymandering. But I think one of the long-term salutary effects, and I think is going to positively impact redistricting, is the transparency provisions of the statewide database. If that census information, if that demographic information, if that election information is all available at SUNY, and people are able to dig in and see what the guts of the redistricting process are like in a meaningful way, sunshine is the best disinfectant, and that is going to lead to better and more public-facing processes that I think is going to improve how we provide representations through districts. So redistricting is obviously a process that doesn't just happen at the state level, right? We see it at the New York City level. We see it within counties, county legislatures and such. And I think the more information we can provide to the public and the more scrutiny we can provide to people drawing districts, the more likely we are to have fair maps.
So were you suggesting, Mr. Pernick, that this bill or this proposed bill should go further to positively address statewide redistricting? Because you said it doesn't have an impact on statewide redistricting.
No,
I thought that's what you said.
I apologize. The pre-clearance regime does not.
Okay.
So the pre-clearance section of the bill does not.
You think that should be beefed up, or you think it's fine the way it is for its purpose?
So I think it's an excellent question. I think we could debate that. I think at the moment, so we have the first iteration of the new independent redistricting commission working on the state maps, right? Beneficially, we only have two statewide maps to deal with, right? The Assembly map and the Senate map. And with the deterrent process that the vote dilution causes of action provide, that might be enough on its own. But if there are concerns about how the independent redistricting process may operate such that we think there's a need for pre-clearance there as well, all you have to do is add the word and state to that particular section of the law, and you're covered. I think in general, pre-clearance is a fabulous idea because it shifts the burden from the people being discriminated against to prove why they're being discriminated against, to the people who might be perpetrating discrimination to prove that actually we're not discriminating at all. I like that as a general regime. I don't like putting the burden on voters to try and suss out when they're being harmed. So I think to put that burden on the state is not a bad one. But fortunately, for the first time this cycle, we're going to have this independent commission. I don't know how presumptively skeptical I am of it.
It's possible that I think you called it the regime, could make an argument that it is not discriminatory, when in fact the results could be discriminatory, in which case it would still be up to the voters. I mean, I find that in government, you could do a lot of things to get to the answer you want. That doesn't mean that as the correct answer. And then my last question to the both of you, if either of you would like, would be to just explain, you both used the word minority. What exactly is a minority? How are you using that word?
So the way we use minority when we're talking about the law of voting rights is racial and ethnic minorities. It is race, it is ethnicity, it is color. It is not simply necessarily a numeric minority. It is not necessarily covering, every conceivable demographic characteristic. We are specifically referring to racial.
So is it possible for, say, a Greek community to be gerrymandered?
It might be possible for a Greek community to be gerrymandered, but they wouldn't necessarily have a cause of action under this particular law. That said, there's possible that there are, Greek is a national origin. There may be Greeks of color. I believe there's a really excellent one playing for the Milwaukee Bucks, so I don't want to be presumptuous to say that Greeks wouldn't necessarily, but...
How about a Russian-speaking community?
Under this particular law, in terms of vote dilution, I don't know that a Russian-speaking community would have a cause of action. Right now, this is limited to racial, ethnic minorities, and issues of color, which have no basis in the law.
What about a community immigrating from Bangladesh?
the community immigrating from Bangladesh, and again, I'm making demographic assumptions here, would probably fall within the racial or ethnic minority because they fall within the category that we commonly understand as Asians.
So for redistricting purposes, you're suggesting that there would be no difference between Bangladeshi voters and Pakistani voters?
For redistricting purposes, I don't know that I would go so far as to say that there would be no difference between Bangladeshi and Pakistani voters, right? When we engage in redistricting, there's a set of criterion that we generally refer to as traditional redistricting principles, right? And that includes things like contiguity, right? The districts all have to be one piece, compactness, they gotta be close together. One of them is respect for communities of interest. Just because you have two groups of people who may look alike but otherwise have very different interests, that may make them separate communities of interest, and dividing them may be an entirely defensible and even a wise policy choice in some circumstances. I don't have the facility with the law, with the cultural history in order to make a judgment there. That said, if you are trying to pack a lot of brown voters into one district because you want to dilute their voting strength, that would not be okay under this law, right? So to the extent that there are, of course, real...
So that would be the racial factor as opposed to like the ethnic factor?
Yes, potentially, right? I would say that typically the term ethnicity factors in here because Hispanic or Latino origin is usually considered to be an ethnicity as opposed to a race, so that's how that terminology has really evolved separately in the law of voting rights. Whether we are considering, Bangladeshi versus Pakistani origin, for example, as race or ethnicity is something we'd have to think about a little bit more, but certainly the color aspect of it is something that is very much within the traditional purview of voting rights. We never think it's okay to just discriminate on the basis of the color of people's skin. If there are other real differences that arise out of legitimate social constructs.
Different languages, for example.
Sure, and of course language is a traditional community of interest, right? And you may look at, obviously within the category of Asian voters, there are tremendous language diversity, and it may make sense, and not just language diversity, but cultural diversity as well, and it may make sense to split up even communities from the same national origin.
My last challenge to you,
Please.
Mr. Chairman, what about a Dominican versus a Puerto Rican community? Or, since you brought up Queens, an Ecuadorian versus a Colombian community.
So,
Same language.
yeah, I'm familiar. I think the Dominican Republic and Puerto Rico are not that far apart globally either. So the answer is it presumptively wrong to treat Puerto Ricans and Dominicans as different for redistricting purposes if they have real separate interests arising out of national origin or other issues? Potentially, right? What we are concerned about is when groups get packed together because of the color of their skin. There is nothing inherently legitimate about saying, we're going to put a lot of black and brown voters, or in one place just because we think they're likely to vote against us and we want to dilute their voting strength. That is not okay. What might be okay, and which I haven't delved into enough on these particular groups that you've raised in order to explain why it might be okay, is where you have real communities of interest deriving out of a shared cultural background. There may be something there. But presumptively, I would say, if you're trying to group together Puerto Rican and Dominican voters pack them together based only on their shared ethnic heritage, I'm a little bit suspicious.
Thank you. I will note that I think both of you talked about gerrymandering and diluting of the vote of a community of color by packing them together. I was often under the impression that actually you dilute a community of color by splitting it apart as opposed to packing them together, which is exactly what was done to the Asian American community when an assembly district boundary was drawn right down Canal Street in Chinatown.
So let me say, it could go both ways, right? Let's say you have enough.
No, I understand how it
Asian
goes
Ameri-
both ways,
it's-
yeah.
Yeah, if you have enough Asian American
But
voting
for
strength.
Asian Americans, usually the concept is, dividing a cluster into two pieces as opposed to keeping it together.
Sure. Let me just posit, if you've got enough Asian American voters to create, let's say, 2 New York City Council seats, and you're packing them all into one in order to deprive the community of a second representative, that's a place where packing could come into play.
Yeah.
But you're absolutely right that cracking is an equally serious problem, and again, one that this law would address.
Cracking versus packing, I get it.
We could talk about shacking later, too. Wait, that didn't sound so good.
This is a family show. This is a family show. Thank you very much, Senator Liu. I would just ask in conclusion, firstly, thank both of you for your work around this issue, for your work on this bill, and being involved in the process. We're very grateful for that. I think we have, some people view these sorts of topics as esoteric, and that, the lawyers start talking and it goes above the heads of a lot of people. And I'm hoping that you could, if you had the opportunity to talk to the everyday New Yorker, to explain to them why it's important that we have a piece of legislation like this become the law.
So the way I like to try and impart to people just how important this is to think about how much your vote counts in local government elections, right? Think about what your school district means, right? School district is the single most impactful local government entity. Its budget is enormous. It is responsible for the education of children. And our turnout in school district elections in New York State is abysmally low, right? Presidential elections, we're lucky if we're hitting 60%. Midterms, we're lucky if we're in the low 40s. Mayorals in New York City, we're looking at 30. School districts, we're frequently under 5%, right? This is the education of our children, right? If we're talking about cities and local elections, we're talking about policing. We're talking about parks, fire, sanitation, transportation, all things that matter to our everyday lives, and in places where elections are decided by dozens of votes, not millions of votes, not hundreds of thousands of votes. You and a bunch of your friends can get together and decide the outcome of things. At those margins, it's incredibly important to make sure that every vote is getting counted, that everybody who is qualified to cast a vote is able to do so, because it's going to impact how elected officials are responsive to you and your community's needs in terms of those everyday basic services. Right now in New York, that's not happening. Right now in New York, we have local governments in particular that are largely unaccountable to most voters. And that really needs to change. We have county boards of elections that are making decisions without the best data available to them, without understanding where people live, where they vote, and how to make decisions that are to include people rather than exclude people. So to make sure that the services that you depend on from government address your needs, your family's needs, your neighbors' needs, your community's needs, we need the New York Voting Rights Act to make that happen.
The one point I'll add, voting should be easy, voting should be fair, and when we have communities where it's easier for people in one neighborhood to vote than folks in the next neighborhood over, or when your vote in one neighborhood counts a lot less than your neighbor's vote, that's a problem. And we know that that happens in jurisdictions across the state. We know that that happens in communities where certain voices just aren't heard, and certain voters aren't counted in the same way, or have other obstacles that they have to overcome. We've been working on these issues in this country for many, many, many decades, and there is still work to go. And that's why this bill is so important for voters across the state in every community, to make sure that every vote is equal and the voting process is as easy as possible and painless as possible, on an equal playing field no matter what community you're from, no matter where you're from, what your background is, what language you speak, really making that process open and accessible to all.
Thank you very much, and thank you both for your testimony.
Thank you both
Thank
so
you very
much.
much.
Next up, we have Eric Friedman from the New York City Campaign Finance Board.
Thank you. It's a tough act to follow, but I'll try to do my best. Good morning,
Morning.
Chair Myrie, Senator Liu. My name is Eric Friedman. I'm the Assistant Executive Director for Public Affairs at the New York City Campaign Finance Board. I want to thank you for the opportunity to provide testimony on the New York Voting Rights Act today. In addition to our responsibilities administering the city's campaign finance program, the CFB is mandated by the New York City Charter to encourage and facilitate voter registration and voting by all eligible residents of New York City, but particularly among populations underrepresented among city voters. It is our mission, our goal, to ensure that all eligible voters are free to cast a ballot with ease and without discrimination. We believe the New York Voting Rights Act is an important step towards ensuring all eligible voters of New Yorkers of voting age, no matter their race, age, sex, gender, country of origin, or language ability, have equal access to the ballot. We don't have broad responsibility for administering elections in New York, but I will focus my testimony today on a few issues that have a particular impact on the work of the CFB, particularly having to do with provision of information to voters with limited English proficiency. As you know, the Federal Voting Rights Act outlines language minority provisions to ensure limited English proficiency individuals are not excluded from the electoral process. While New York City currently provides interpretation services and translation of election-related materials, including the CFB's voter guide, in Spanish, Chinese, Korean, and Bengali in addition to English, hundreds of other languages are spoken by New York City residents. Of our 1.8 million limited English proficiency residents, about 300,000 speak a language that is not covered under the Federal Voting Rights Act. Providing interpretation services and translating election materials into more languages for our underrepresented groups is essential to increasing participation in our democracy. Oftentimes, these communities do not receive adequate guidance at the polls, which can prevent them from voting as they intended or deter them from voting at all. Our research into voting behavior shows that lack of information is the main barrier to participation in our elections. The New York Voting Rights Act could potentially expand the requirement to provide translation and interpretation services for ballots, poll site assistance, and even voter guides to include several languages not included under the federal VRA formula. This will represent a significant and worthwhile investment in expanding access to voting information for these currently underserved populations. Our analysis of voter behavior in previous election cycles also shows that turnout is especially low in neighborhoods with high naturalization rates, which are often neighborhoods with limited English proficiency voters. For this reason, we have set an ambitious goal to register and engage 20,000 naturalized citizens in 2020 and drive up turnout in 10 neighborhoods across Brooklyn and Queens that have high naturalization rates and persistently low voter turnout. By expanding language access to voting materials across the board, the New York Voting Rights Act will help the CFB better accomplish this goal. Through our provision of voting information, the CFB willingly complied with pre-clearance requirements under the federal VRA until the Supreme Court effectively eliminated them in 2013 in Shelby County v. Holder. And we've supported previous efforts to institute a pre-clearance requirement at the state level. The New York Voting Rights Act restores this important oversight mechanism, which will ensure that jurisdictions cannot roll back rights gained by New York voters. Requiring election administrators to seek approval from the State Attorney General's office prior to changing voting procedures is an important protection to ensure no New Yorker faces new obstacles to casting a ballot. Situating that review in the Attorney General's office, much as the Federal Voting Rights Act did, is the appropriate location for such a provision. The U.S. Justice Department Civil Rights Bureau handles violations of the VRA, so the State Attorney General's office is the logical location for the New York Voting Rights Act pre-clearance provision. The CFB welcomes this important oversight that aims to guarantee New Yorkers' access to the polls or to important voting information will not be undermined by any future administrative action. In short, the CFB supports the New York Voting Rights Act. In the absence of the protections previously afforded by the Federal Voting Rights Act, we urge the enactment of this important legislation that will ensure all New Yorkers of voting age have equal access to the ballot. I want to thank you again for the opportunity to provide testimony today, and I'm happy to answer any questions you might have.
Thank you very much, Senator Liu.
Thank you, Mr. Chairman. Thank you, Mr. Friedman, for joining us, and I appreciate your testimony. I think what is a pretty simple question for you, which is when the CFB registers voters, and I may or may not applaud the CFB's efforts to register voters. And here's what my question is. When a government agency like the CFB registers voters, what do you advise or educate new voters or people who are completing the voter registration forms about how to check off the party enrollment box?
It's a good question, and I recognize that you know, we're a nonpartisan agency, right? We independent from City Hall and are studiously, we attempt to stay nonpartisan in all of our activities.
So how does the CFB address that?
So it was a question we get a lot, and really it's just kind of a straightforward explanation of. I think this is a particular challenge that we find in communities with limited English.
The CFB is
explaining what is a primary election and what's a general election, and explaining to voters that they cannot vote in a primary election of that party unless they're registered as a member of that party. You know, it is a question we get a lot from in the field.
Well, the CFB encourages people to register to vote.
Correct.
Does the CFB encourage people to also vote in primaries and do what is necessary in order to vote in primaries?
I think from a perspective of remaining nonpartisan, what we can do is explain the difference between a primary and a general election and say, and explain that in order to vote in a primary.
In the past, when the CFB registers voters, has the CFB taken a look at the enrollment rates of the people that the CFB has registered to vote?
I'm sorry, could you?
Well, say the CFB goes out and registers 1,000 people.
Yes.
Which is not easy. But you go out and register 1,000 people. Does the CFB take a look at, you know, of those 1,000 people, how many registered as Democrats, Republicans, or chose to remain independents, or chose another party?
We have not taken a close look at how many of the voters we registered.
I would like to
are
ask
broken
you
down by party.
to go back to the Campaign Finance Board, and in these upcoming efforts, when you get the registration forms back,
Yep.
because I assume, I mean, it's always the best practice to take those forms back as opposed to letting people fill it out at their leisure and then promising you that they will mail it in.
That is correct.
Right? You take them back and you take it to the Board of Elections. That is the best practice. When you do so, you can take a look at how many people are registering Democrats, Republicans, unenrolled, and other parties. And my guess is that most people that the CFB registers are going to be unenrolled. And I say that because that's what I've heard. I don't have any evidence to back that up, but it is an absolute, I don't want to say absolute, but it is in a large proportion of the cases, especially in a city like New York, an actual disservice to a potential voter by not encouraging them to check off a party box, because their vote becomes irrelevant in the primary. Well, they don't have a vote in the primary. In the general election, as you know, in 90% of New York City, the general election doesn't mean anything, does not determine anything. So the election is determined in the primary. But if the CFP goes out there and, admirably so, registers a ton of voters, the vast majority of whom do not check off a party box, you're actually making it harder for those people in the next and successive years to start engaging in the primary vote. And that's something that I think we need to be very careful of. I understand that you can't be partisan, but I think even the Campaign Finance Board can encourage people to take part in the primary process, not simply by encouraging them or educating them what the primary is and how to vote in a primary, but really, in outright encouraging them, check off a party box.
So I'll say this, and again, being mindful that we are very cautious not to urge voters to register in one party or another.
Of course, I certainly would never suggest that.
We have not, to my knowledge, done research into the partisan enrollment of the voters who we have registered through our activities. If that's data that we can get our hands on, it's worth taking a look at if it is an area of concern. That said, I think one of the observations that I would make is that I think a lot of the obstacles that people talk about to voting, the most important one is kind of lack of information and understanding of the process. And again, particularly
And sometimes fear.
True. And particularly among some of the communities with limited English. And so it is a particular limited English
I mean, it's not even
proficiency.
limited
So
English.
it's a particular challenge to provide that.
You're talking about
information
engaging
about-
20,000 naturalized citizens, right? A lot of times, the immigrants are immigrating from countries where, it's not a good thing to be a party member. Here, being a party member means you just check the damn box and you can vote in the primary. And we need to educate, but also encourage people to do that. I think the first, it's certainly not the first step, but the next step the CFB can undertake is take a look at those 20,000 people who you engage and register, and look at what rates they're checking the various boxes in the enrollment section.
So I'm happy to research to the extent we're able, and we're always trying to do this the right way, get it right. So I'm happy to take that feedback and consider it. So I appreciate the comment.
And the Campaign Finance Board always publishes good reports, with one notable exception that I will not mention right now. But is there going to be a report that discusses the voter registration efforts? The plan, the ambitious goal of registering 20,000 people. Are we, maybe like towards the end of 2020, we can get another one of those CFB reports that talk about how many people were actually registered, and enrollments, and problems, issues, and what could be done better, or perhaps additional changes in state law that our chairman can consider.
So under the city charter, we publish every April a voter analysis report, which contains a lot of the information that you described, a summary of our activities during the year, and numbers of people who are registered and effectiveness of those activities. It has contained in past years and will again recommendations for reforms to state election law to help increase access to elections. We are currently at work on this year's report, which again we expect to publish in the middle towards the end of next month.
Thank you, Mr. Friedman. Thank you, Mr. Chairman.
Thank you, Senator Liu. I just have one question on the limited English proficiency attempts. We, as you stated in your testimony, and we appreciate the expression of support, we are increasing, or rather decreasing, the threshold and increasing the ability of the state that surpasses the federal mandate to have language access. And there are some folks who have expressed reservations about that, who said that might pose an administrative burden to present language access to the extent that we are requiring. And I'm hoping that you can speak to why you are supportive of that provision in our bill, and what you've seen through the CFB's experience in providing language access and the need to expand it.
Well, again, I think I'll go back to something that Perry said when he was finishing up. The main barrier, I think, for just about any voter, whether they speak English or another language as their primary language, is kind of the lack of information about how voting in local elections or state or federal elections has an impact on their day-to-day life, on the issues that they care about. When they wake up, when they go to sleep, and so I think once you paint that picture for folks, they're gonna want all the information they can about how do I vote, where do I vote, what does a primary election mean, what does a general election mean. So, we have currently a large number of people in New York City who are not served, for whom that information is simply not available. Again, we provide that information to many voters with limited English through the voter guide. We would like to do more. Being prodded to do more and having that mandated in law is an important provision and protection for those voters. Because you're right, there is work involved with translating all that material into various languages. It's work that we've done for 30 years through the publication of the voter guide. It requires an investment of resources and staff time, but it's an important one if we are truly committed to bringing everybody, every resident of New York City, New York State, who is eligible to vote into our democratic process, opening up, bringing them into that conversation about, what's at stake in every election is an important one. Making sure that they are able to navigate that polling place with confidence is an important one. And so it absolutely does require an investment of resources and time. It's one that's worth making, and it's supremely important to the legitimacy and the responsiveness of our democracy.
We'll note that we've been joined by Senator Jamal Bailey. Mr. Friedman, thank you very much for your testimony. Next, we have Susan Lerner, Executive Director of Common Cause New York.
Thank you so much for the invitation to testify, and I start with an apology that we were unable to complete our written testimony in advance. We will do better. But I will be sure that we have our written testimony to the committee by the end of the week. So what I'd like to do today is talk in more general terms because in terms of detailed comments on language and specific provisions, we'll go into detail in our written testimony. First, sorry, let me get a little water. As I think you're aware, one of the major issues which Common Cause New York works on is voting rights and ensuring to the best of our ability that every eligible New Yorker has access to the ballot and that they are confident and that indeed their ballots are secure and accurately counted. And so we see the New York Voting Rights Act as a very important part of an important step towards achieving that goal. We also are one of the members of the steering committee for the Let New York Vote coalition, and the New York Voting Rights Act is one of the coalition's legislative priorities for this legislative session. So we are delighted to have an opportunity to look at the bill and to discuss it. In all honesty, from my point of view, I think this is an extraordinarily important and precedent-setting piece of legislation, and if enacted in law in any format, would have a huge impact. To me personally, what really struck me first is how extraordinary the provisions in Section 17200 and 17202 are in the context of our election law, and how, if enacted into law, would have an impact on every single voter, not just voters of color within our state, because our experience has been that our election law is very, very strongly biased towards parties and candidates, and in most instances overlooks voters. And this was brought home to me very sharply with a story that Assemblymember Abenante likes to tell, that when he was practicing election law as a private lawyer, he was hired by a woman whose affidavit or absentee ballot was being challenged by candidates and was going to be litigated in court as to whether her vote would count or not. And she hired him to go into court and to advocate on her behalf as a voter. And Tom Abenante tells the story that he was tossed out. He had no standing. As the representative of a voter in a contest over whether her vote would count, she had no voice. So I see these two provisions as absolutely making a huge impact in that regard, allowing a court to focus on what's important to the voters and reminding the Board of Elections that, as Dustin Czarny said, they actually need to serve the voters. It's not just about the candidates and the parties. It is about the franchise for all eligible New Yorkers, which is why the rest of the provisions are so important, because of the problematic history of our state, that we need to be sure that those who have been denied the full access to the franchise are protected. And from my point of view, as somebody who does extensive work on redistricting, who in the last cycle helped to draw reform maps and hopefully will have the resources to do that in the future, the provision which requires that information actually be centralized also has a huge impact. One of the things which makes it most difficult to do reform work and to protect voting rights across the state, and it's a problem we at Common Cause see across the country, is that pre-clearance gave us centralized information. As Perry pointed out, the problem with the Shelby case is that it puts all of the onus on the challenger. That is time intensive, and frankly, sometimes we just don't know about the problems, where pre-clearance allowed us to see what different jurisdictions were doing. So we at Common Cause now have had to file lawsuits across the country, in Georgia, in North Carolina, in other jurisdictions, which I believe would have been unnecessary with pre-clearance. Having a repository of accurate information that just automatically every single jurisdiction that runs elections has to report to will make all of our jobs much easier. And I do agree with Perry that if people know that they have to report, they are more likely to be careful. I don't think there's any guarantee that some people who are bound and determined to do nefarious things will be constantly discouraged. But shining a light on it and making it accessible to those of us who are watchdogs, who are interested in seeing what's going on, is going to be a tremendous benefit. As will pre-clearance. Common Cause has filed 3 lawsuits in the past 5 years around election law. One where we filed to be sure that the ballot in 2014 accurately described the Redistricting Commission, and the court agreed with us it's not an independent commission. But then we've also had to file against the New York City Board and against the State Board regarding registration practices that really were problematic. Pre-clearance will take a burden off the advocacy community and again put the onus on those who are actually in control, rather than forcing us to figure out how we can get the resources to do the necessary research to bring a lawsuit which is incredibly time-intensive and expensive. The legal fees, the pro bono legal fees for the suit that we brought against the State Board totaled over $1 million. And it took 1.5 years of lawyer and advocacy time, as well as expert testimony. Pre-clearance simplifies the process and is extremely important. Again, I think the details are very important, and that's what I'll address in my written testimony. I do agree with NYCLU, do not put the repository in the State Board. The State Board has a hard enough time keeping track of the data that they have to keep track of for election purposes and for campaign finance purposes. This data is too important, and it needs to be manipulated in a very nonpartisan and scholarly accurate way. And one of the things which unfortunately we see in our election system, which Dustin Czarny touched on with a different conclusion that I reach, is that the partisan nature of our boards of elections, frankly, don't make them a good repository for what needs to be very accessible information that is available to the public, to advocacy groups, to scholars. And so SUNY really is the right place. But again, we're going to need resources, has been pointed out earlier. I will have more to say about the specifics of the way in which lawsuits would be determined. But I do want to say that I did agree somewhat with Bob Brehm. When we're talking about certain presumptions, I think it would be surprising to the people who made the determination to hold local and school board and other local jurisdiction elections on off years, that there's a presumption that it's done only to discourage minority voters. I would point out it discourages all voters. And so if we're going to have a presumption against that practice in only certain circumstances, I would urge from a good government point of view, let's have an honest discussion about the pros and cons of doing it for everybody, because it does decrease turnout. On the other hand, people argue that the concern is that if you have all of your elections at the same time, there's a huge fall off with the down ballot elections, and people will just overlook the local and school board elections. I think it is a discussion worth having, and I think that there are more problems than simply the impact of having off-cycle or off-year elections for our lower jurisdictions than its impact on communities of color and traditionally marginalized communities. So let's have a discussion about that. Let's also have a discussion about whether we should have at-large districts at all, whether we should go to a districted system throughout, rather than taking only this portion of the problem. It has a lot of consequences, and it often is negative. Perhaps we should just address that separately, not simply within the context of its impact on communities of color, but rather a larger discussion about whether it is something which should remain within, as was pointed out, our home rule law that makes it that much difficult for a jurisdiction to decide on its own. So those are areas which I think we should be having a more general discussion. Voter intimidation and deception, again, we're going to have some specific comments on language. We're very supportive. It is badly needed. In every election cycle, with our election protection efforts, both on the ground and with the phone hotline, we get calls from people who've received misinformation, either through phone calls or through mailers, which are designed to confuse the voter. And we'll make some suggestions, because I think there would need to be further tools within these provisions that allow you to track down who actually is disseminating this misinformation. Because those of us who try and counter the information and then try after the fact to hold the misspeakers responsible find it's very difficult to track them down. And so I think we may need to do some thinking about that. Lastly, we're very supportive of expansion of the requirement for language assistance. Our experience in trying to get the word out for early voting, our experience in trying to communicate other possible voting reforms in numerous different languages to at least New York City voters and voters in other places indicate how important it is and also how challenging. So I think we need to have some discussion about what is the appropriate number. 5,000 is too high. Is 2,000 too low? I have no idea. But I think we need to look at the data and see which jurisdictions would be brought in if we have, with which number. The number clearly should be somewhere. It could be 2,000. It needs to be below 5,000. This I think would benefit from some analysis of which jurisdictions would be drawn in. And those are really my highlights in terms of the things that we've been thinking about in relation to this really salutary and incredibly important piece of legislation.
Thank you first, Senator Myrie, for this legislation. You spoke to me about this. And as the chair of our elections committee, you're doing one hell of a job, I have to say. I just had to make sure I made that editorial statement, and we really believe that you're doing a phenomenal job. And to all the advocates who have testified prior to my attendance, and when I have to go leave in a second, I thank you for your testimony and for your commitment to ensuring that we preserve the rights of the voters. So, Susan, thank you. I guess I would just say a comment for you, and I await the written testimony to see some of the more specifics, because I know how detailed you and Common Cause are. I would just say that the language access portion to me is a critical point, and I didn't get a chance to talk to the CFB folks, because we're talking about new immigrants in our communities, in our societies, and there's so many different languages and different dialects, and I just want us to be mindful of those individuals who, on one part of the coin, we say, get out there and vote. You have to do this, or else your voice doesn't count, and we make these grand statements, right? But if we're not giving people the access and opportunity for them to actually be involved meaningfully in the process, because there's a level of involvement that we can have and say, hey, you're just registered to vote because we want you to vote. But there's an actual thing about education and people knowing what's on the ballot, and not just the ballot questions. And so I just wanted to make sure that for me, language access is critically important, and I'm hopeful we can have more of a conversation about your commitment to ensuring that we can get more language access, because in my district there is a heavy Bangladeshi population who are they're growing in numbers every single day, and sometimes they feel disenchanted because they can't participate at the levels that they want to, and we tell them to go vote, but they don't understand. We're not giving them the tools to be able to understand how to do that. So I would just make sure we make that statement.
I think it's an essential part of this bill. I think that it really fills out its goals very, very well. My only question is, what's the right level to decide to add language access? One of the most fun days we had in our ranked choice voting campaign was helping to mediate a discussion between 3 Bangladeshi speakers in terms of the translation for the materials that we were putting out for the Bangladeshi community. So it's a fascinating process. I've learned a lot about voting in other places because our system is so different from so many of the systems that our new Americans are used to. There's a lot of explaining that we need to do, and we're very supportive of that. My only question is, let's pick a level that hits the right number of people so that we are using our resources most significantly.
Thank you.
Thank you, Senator Bailey, and thank you, Susan, again for your testimony. We very much look forward to the written testimony and continued discussion on how to make this the best bill possible, but we are very grateful for the work that you do, so thank you.
Great, thank you.
Thank you. Next up, we have L. Joy Williams, president of the Brooklyn NAACP. I will also note that we received written testimony from the NAACP's Legal Defense Fund in support of the Voting Rights Act. We will hear from L. Joy next.
Good morning.
Morning.
It's kind of dead in here.
Yep. 12 minutes after 12, so we're in the afternoon now.
All right, good afternoon.
Good afternoon.
All right. Good morning to Senator and to the staff. Since you don't have colleagues, I'm going to say to the staff who I know are working very diligently and hard on this legislation. As a former staffer, as they say, once a staffer, always a staffer, in the instances that I can highlight the work of staff who helped to put this together, I will certainly do so. For those not sure, I'm L. Joy Williams. I'm the president of Brooklyn NAACP, the legislative coordinator for the New York State NAACP Conference of Branches, and I bring testimony on behalf of the thousands of members of the 51 active NAACP branches across the state of New York, which is under the leadership of our New York State Conference President, Hazel Dukes. I thank you for the opportunity to testify. This is part one of our testimony on this bill, and part of a number of actions that the New York State NAACP will be taking on this issue. The longstanding mission of the NAACP is to ensure the political, educational, social, and economic equality of rights of all persons and to eliminate race-based discrimination. And the right to vote has always been one of the utmost priority of the NAACP. And for almost a century, we have fought against those who wish to suppress the votes of African Americans and other racial or ethnic minority Americans through unfair or unjust laws, deception, and or intimidation. As a result of the Supreme Court decision in 2013, there are currently no states or jurisdictions which are required to comply with the pre-clearance directive under Section 5. And that's mainly what I would like to focus the conversation on this afternoon. So this means that states or jurisdictions with a proven history of discrimination and suppression are able to make changes to their election laws and policies without proving in advance that those proposed changes will not disenfranchise any voters. And New York itself has an extensive history of discrimination against racial, ethnic, and language minority groups, and there exists a persistent gap between white and non-white New Yorkers in political participation and elected representation. And due to that abhorrent history, several counties became covered jurisdictions under the federal VRA. But I don't want to feed the narrative that voter suppression has only occurred in the past, or that voter suppression actions come only from evil men in white hoods, with the expressed intent to discriminate and suppress political participation of African Americans and other people of color. Voter suppression regularly occurs here in New York today. That can include moving poll sites without adequate notice to voters. That's voter suppression. Lack of funding for us of providing voter education and election notification is part of voter suppression. And the use of at-large elections, which are susceptible to minority vote dilution, we also assert that that is voter suppression. So voter suppression, as we say in NAACP, or discrimination, does not have to be well-intentioned policy that is not implemented correctly or with all communities and all voters in mind, and how those policies and laws would impact those communities. That is suppressing of the right of people to vote. To that point, on recent voter suppression, I will just highlight in one particular case that NYCLU, the New York Civil Liberties Union, joined us, the Spring Valley branch of the NAACP, in 2017. I believe this trial is going on as we speak, to challenge the at-large system of electing school board members, which significantly disenfranchises Black and Latino voters and in turn significantly impacts the education of Black and Latino students. At-large voting boosts the electoral strength of a majority and diminishes electoral opportunities for minority voters. The Supreme Court itself noted this challenge and the potential discrimination for at-large voting, stating that voters who are members of a racial minority might well be in the majority of one district, but in a decided minority in the county as a whole. At-large voting would therefore nullify their ability to elect the candidate of their choice, just as would prohibiting them from voting at all. The NAACP is fully committed and support all of the provisions outlined in the New York State Voting Rights Act, and this legislation is central to our legislative agenda. All of our branches and a representation of our members will be here on the 17th of this month, continuing the advocacy not only for the New York State Voting Rights Act, but in all of our legislative agenda items. And central to that agenda is the New York State Voting Rights Act, because we believe political participation and representation and access to the franchise to vote is central to equity in our political realm. So we emphatically support this legislation, but to make note that some of the advocates have already made, it's not enough to just pass this without any funding that would align for whether it's for the New York State Attorney General's office in terms of pre-clearance standards, in terms of all of the local board of elections in other places and regions of the state who will need ongoing support and financial resources in order to implement or even as further further down the line, they try to implement different aspects of election law. So just as I said before, that well-intentioned things can be voter suppression, passing the New York State Voting Rights Act without any clear indication of how all of the counties will be able to comply, making sure that the resources are available in the Attorney General's office and other Board of Elections and in the state have the resources to follow suit is extremely important. So New York has made commendable strides to improve access to the franchise by enacting many election reforms that the New York State NAACP has advocated for decades. But many discriminative practices remain, and opportunities for discrimination remain widely available. We have the opportunity to put in place procedures that will enable us not only to end discriminatory practices, but also put in place a structure that will prevent any attempts, whether intentional or not, in the future. Thank you for this opportunity.
Thank you very much. And seeing as though none of my colleagues have any questions, I will just say, we're grateful for the support from the NAACP. I think something that you said is really important in that voter suppression, part of what makes it so insidious is that it's hard to find and hard to detect and hard to see. We know who comes to the polls. We don't know who doesn't and why they didn't. And the NAACP, as you mentioned, for the past century, has been fighting to protect those who have been unseen and who've been intentionally pushed out of the conversation. So we appreciate that support, and we look forward to working together to make this the strongest piece of legislation that we can have to protect the franchise. So thank you very much for your testimony today. And next, yes, round of applause, round of applause. Next we have Juan Rosa, who is the Northeast Director of Civic Engagement for the National Association of Latino Elected and Appointed Officials.
Well, I do appreciate the pay raise. My name is Benny Poi.
Okay, I'm sorry. I'm sorry.
It is actually
congratulations.
Yeah, thank you. That's actually a compliment, so thank you. Chairman Myrie, thank you so much, and thank you, members of the Election Committee in spirit. Thank you for the opportunity to testify today in support of the New York Voting Rights Act. On behalf of the National Association of Latino Elected and Appointed Officials, or for a less mouthful, NALEO Educational Fund. The NALEO Educational Fund is a leading nonprofit, nonpartisan organization that facilitates full Latino participation in the American political process. From citizenship all the way to public service, our constituency encompasses the more than 6,800 Latino elected and appointed officials nationwide, and includes Republicans, Democrats, and independents. In New York, persistently low voter participation rates are strong evidence that election laws and procedures can and must improve. We are particularly concerned that significant disparities persist in the turnout rates of voters of different races and ethnicities. For example, during the 2018 general election, a higher percentage of non-Hispanic white New Yorkers than of New Yorkers of any other race or ethnicity cast ballots, and the disparities were stark. Just 32.4% of eligible Asian Americans and 40.9% of eligible Latinos voted, compared to the nearly 53% of non-Hispanic whites. The communities of voters who experienced savage, undisguised discrimination before and during the civil rights era are the same communities that are targets of contemporary discrimination. They continue to be underrepresented in New York polling places in election after election in the modern era. Laws and administrative policies governing the conduct of elections that are designed to discriminate and have discriminatory practical effects are a reason for the state's persistently low overall voting rates, and for the disparities between the electoral participation rates of New Yorkers of varying races and ethnicities. The history in the state of implementation of discriminatory voting procedures portends future danger and demonstrates the importance of strong defense of the equal right to vote. For example, on the day of the 2016 primary, numerous voters in Kings County went to the polls to discover that their names did not appear on the poll books. Eventually, advocates learned that more than 122,000 Brooklyn voters had their registrations canceled less than a year prior to the hotly contested presidential primary. This extensive purge of voter registration records employed improper methods, and its victims were disproportionately Latino and Asian American voters. According to an analysis by the radio station WNYC, this operation removed the registration of 15.2% of all likely Latino voters in the borough, but just 9.5% of all non-Latino voters. Another enduring challenge of New York voters of color is insufficient provision of language assistance, as mentioned earlier. The manifest in incidents such as the Asian American Legal Defense and Education Fund's observation of Chinese interpreters trying to assist Korean-speaking voters at a polling place in Queens in 2014 due to personnel shortages. Naleo Educational Fund and our partners in the Election Protection Coalition received voters' reports on Election Day in 2018 of missing or inadequate Spanish materials and interpreters at multiple locations in Queens and Brooklyn, following a pattern we observed in the 2016 general election and previous cycles. On Election Day 2018, the New York City Board of Elections noted that it received more than 10,000 calls about equipment breakdowns, more than 5 times as many as it received in 2016 during a higher turnout election cycle. These failures produce long lines to vote, a problem that occurs more frequently in communities of color around the nation. Numerous studies relying on differing indicators have found that African American, Latino, and other voters of color wait longer at polling places today than non-Hispanic white voters, and are disproportionately likely to face a wait of 30 minutes or more. Many voters are unable or unwilling to ensure these waits, and experts suggest that many hundreds of thousands of votes at least are lost in a typical federal election because of long lines. These examples are representative of other similar incidents and illustrate how law and policymaking may abridge or deny the right to vote to members of historically underrepresented communities throughout New York. It is particularly essential that states and localities take action in 2020 and beyond to defend equal voting rights against incursions like these, because the Federal Voting Rights Act is not at full strength, and weakened by federal anti-discrimination protections have made it more possible and likely that discriminatory election policies go unchallenged and mar our democracy. We applaud the Elections Committee for taking this step today to examine the problem of unequal access to the democratic process and to make the law to readdress it. The New York Voting Rights Act, the New York Voting Rights Act comprehensiveness and attention to empowerment, bless you, of all the state's many diverse historically underrepresented communities are guarantors of its future success in ensuring that New York elections are equally open to every one of its citizens. Thank you for holding this hearing, and thank you for taking our views into account as you consider this legislation.
Thank you, Mr. Poi. I will note that we've been joined by Senator Kavanaugh, who for many years carried the mantle of voter protection as the ranking member on the Elections Committee. And so we're happy to have him. I do not have any questions, but just wanted to thank you for your patience. We have reviewed the written testimony that was submitted, which was exhaustive, and so we appreciate the effort that went into it, and we look forward to working with Naleo on efforts to make it a strong bill.
All right, thank you so much for your partnership.
Thank you. And next we have Jennifer Wilson, Deputy Director of the League of Women Voters.
Good afternoon, Senator Kavanaugh, Senator Myrie. Thank you, Senator Myrie, for introducing this legislation, also for holding this hearing today. The New York State Voting Rights Act is a thoughtful, comprehensive policy that will ensure strong protections for voters and increase transparency and accountability in New York's elections procedures. We are pleased that you collaborated with the New York Civil Liberties Union and NAACP on crafting this very thorough policy. And there are many impactful civil rights groups who have already testified and will still testify today, and I believe they have done an excellent job describing exactly how this policy impacts the community they serve. So as not to take away from the rest of the testifiers today, I only want to highlight one aspect of this reform that directly impacts the work of the League and our grassroots members. Section 3 of the New York Voting Rights Act will create a statewide database of public elections information, including voter lists, voter history files, maps of legislative districts. Each year, the League provides comprehensive election information through our online ballot program, voteforone.org. We cover all races from the dog catcher to the U.S. president, and we provide strictly nonpartisan information that comes straight from the candidates running for these offices. The ballot program is viewed by over 500,000 voters in New York State each year, and this year we partnered with NALEO to translate our guide into Spanish as well, and we expect our views to increase tenfold in the upcoming election. The guide uses GIS maps of legislative districts to give voters a precise ballot that shows every single race that's going to be on their ballot. It can be very difficult to source these maps and complete lists of candidates in certain regions of New York State. We're lucky to have local chapters that have direct relationships with county boards of elections, but other individuals trying to replicate this program might not be as fortunate. The Voting Rights Act will instill much-needed transparency in our elections process, and we again applaud the sponsor for introducing this legislation, but want to remind the Senate that much like other progressive policies that were passed in 2019, this reform has the potential to increase the funding burden of both county and state boards of elections. In light of the continuing budget negotiations, we urge the Senate Elections Committee to consider the impact of the impact that the cost of this policy and other new elections policies will have on localities and the state. Without funding, election administrators will be unable to respond to court sanctions, provide information to a statewide database, add additional interpreters of ballots in other language, or to respond to public inquiries about a given policy. We appreciate the immense thought and consideration that has gone into crafting this policy, but we hope lawmakers will consider the importance of funding such a reform so it can be realized to its full potential. Thank you again for the opportunity to testify today, and we look forward to seeing this policy passed and enacted into law.
Thank you very much,
Thank you both.
and thank you for your patience.
Oh.
We appreciate the work that the League is doing. Thank you.
Yeah, no, you guys have a great list of testifiers today. I'm happy everybody came out.
Great, thank you. Next up, we have Amy Torres. Yeah, we're doing rounds of applause for everybody. Next up, we have Amy Torres, who is the Director of Policy at the Chinese American Planning Council.
Good afternoon. Thank you,
Afternoon.
Chair Myrie. Good afternoon, Senator Kavanaugh. My name is Amy Torres. I'm the Director of Policy and Advocacy at the Chinese American Planning Council, CPC. CPC is the nation's largest social services organization for Asian Americans and Pacific Islanders in the country. We're rooted solely in New York City, providing services to 60,000 low-income immigrant New Yorkers each year. We do that across 30 different sites in family support, education, and community and economic empowerment programming. And we firmly believe that the right social services can incite social change, which is why we also do civic engagement, voter education, and voter empowerment work as well. So I have had so much fun sitting in on today's hearing, hearing everyone share their support for the New York State Voting Rights Act. I'd like to focus my spoken testimony on the barriers faced by low-income immigrant and Asian American communities, and then around some of the data sourcing in the centralized database. So Asian Americans and immigrant New Yorkers in particular are a growing electorate. They make up 1 in 5 New Yorkers is an immigrant in terms of immigrant voters. They make up 1 in 4. Over 80,000 New Yorkers naturalize each year. So it is a growing electorate. The diversity within this group makes up the diversity of the rest of the world. Asian Americans are the fastest growing racial group and are also taking up a larger share of the electorate. In the last few years, they've also been bucking trends in voter participation and turnout. So after the last presidential general election, 30% of Asian Americans polled in ALDEF's nationwide survey said that they voted for the first time. And during the midterms in 2018, Asian American voter turnout increased by 40%. So despite the growth of this electorate, there's still several societal and systemic barriers that prevent Asian Americans from fully exercising their influence at the polls and realizing their political power. Language diversity is, of course, quite vast. Asian Americans come over from over 30 nations, speaking 100 languages, and then countless dialects within those languages. And then they also sit at cross sections of different identities. So whether those are national ties, ethnic ties, there are deep roots of trade, migration, and histories of colonization in Asia that people carry into their identities when they move here to the US. Language identity and identity present challenges for voters and boards of elections alike. So in the 2000 state Supreme Court race, language mistranslations on Chinese ballots directed voters to select two candidates, and then in the simplified, or the translation between simplified and traditional were incorrect, causing several of those ballots to then be discarded. And then we know that boards of elections are also using surname analysis in their provision of services, but for as an Asian American with the last name Torres, for other Asian Americans with names like Castellino, Mallorca, there's a lot of us, and we're not Spanish speakers, but it's a legacy of a long history that means that surname analysis is not always the most effective tool for service provision. So from registration to the polls, a lack of tailored language access services continues to present these barriers. So when we're looking at things like a centralized database on election data, we have a few recommendations that we'd like to share. Often the growth rate of the community means that the data collection and data fields aren't necessarily responsive. And some of the fastest growing communities for immigrants and Asian Americans in New York State are in places that do not collect that data or would not yet be reflected in the decennial census reports. And even within the ACS, some of the in the American Community Survey, some of the categories do not fully capture languages that could be provided, as is in the bill right now. So the highest Asian language spoken is Chinese. The second highest language is the category Other Indic Languages. So if you were looking purely at ACS data, you would actually need to go into the Public Use Micro Data Survey, PUMS, to then back into what those other Indic languages are. But the PUMS reports don't disaggregate by state legislative districts, and then the ACS itself is also just state legislative districts. So we would like to recommend that this database clearinghouse includes publicly available data from public offices, even if they themselves may not be statewide. There were data disaggregation bills. There was a data disaggregation bill passed in the Senate with one of the members of the Elections Committee, and passed through the Assembly as it had a number of years, but did not become law. But we know that localities have passed their own data disaggregation bills, and that publicly available data could potentially fill gaps in what the ACS surveys report. And then our other recommendation would be that in whatever formula the central database is considering, is that there is going to be a lag between the Census Bureau's publishing of schedules and the number of people who age into citizen voting age population, as well as people who naturalize into, in the 2 to 3 year lag between the collection of data and the publication of it, and then the eventual implementation of it. So especially with reforms like pre-registration of 16 and 17-year-olds, we can presume that a considerable number of 18-year-olds will now show up on the polls, and with over 80,000 New Yorkers naturalizing each year, we think that should be a consideration as well. I would like to briefly talk about pre-clearance and civil liability. I may just skip to civil liability for voter intimidation. You know, in addition to the voter engagement and education work that CPC does, we also like to hear back from our community members and keep them engaged in the process. So even before people are eligible to naturalize, they can serve as poll workers and poll interpreters. We also have a number of staff who take election day off in order to serve at their polls and provide language access services. And when we hear back from community members and when I hear back from my own colleagues, some of the comments that I hear are very disheartening. People feel rushed to fill out their ballot. People are unclear about whether they can ask an interpreter for help, whether they can bring someone of their own choosing into the polls with them. And then we've also had a staff who recently turned up to their shift and they were told, this is for citizen voters only. You cannot come in. And he had to say, I am a poll worker and I can come in. So, you know, the perpetual foreigner myth continues to impact our community members, and particularly at this moment in time. So while we know there is a criminal statute where language is centered on explicit threats of violence, force, or injury, we know that with the federal anti-immigrant rhetoric, as well as hate crimes that are rising closer to home, people are more reticent to stand up and enforce their rights for fear of retaliation. And we also know that this threat of the specter of violence doesn't need to be explicit. As Senator Leo mentioned, a number of our community members come from repressive regimes at home. People often mistake Asian Americans as being apolitical, but it's as a community that receives a high number of asylee applications, it's actually because our communities are so political that they're coming here. So, you know, there's a lot of that holdover anxiety, but we don't necessarily need to even look overseas to have historical precedents of voter suppression and violence. It weighs heavily on all of us that this is the Tuesday after the 55th anniversary of Bloody Sunday to have this hearing, which is so historic and so important and so exciting. So we're very pleased to see that the civil liability for voter intimidation is included in the bill, and that the financial burden and risk associated with litigation would be lifted. So thank you very much for your time, and we're very pleased to continue to partner with you.
I'll just comment. You know, in the interest of time, I want to ask a question, but thank you for. Is that better? Yep. Just in the interest of time, because we have a number of things we need to get to today, but I just want to thank you for your testimony, for all your tremendous work in Chinatown and throughout New York to represent these communities. And obviously we will be reviewing written and comments as we go forward. And I also just want to, since I haven't spoken before, just thank the chair of the committee for putting forth this incredibly important and thorough piece of legislation, which we look forward to working to advance. But thank you.
Thank you.
Right. Yeah, again, thank you very much for all of the work. As you know, CPC does great work throughout the state, but also in my district out in Sunset Park. And I've had conversations with a number of the CPC employees that do democracy work, and we are very grateful for that and appreciative, particularly around early voting, which has been very helpful. And I've reviewed the submitted testimony. We look forward to continuing to work with you. I think you've already addressed, I was going to ask what you felt the biggest factors were that discouraged participation of the AAPI community. I think you've already addressed some of that, but if you could, I guess, succinctly say kind of what the main protection you guys would be seeking and what would help drive up participation.
I think language access is so key. I have a lot of things to say about this. I think language access, really lowering the threshold, is so critically important. There isn't currently a mechanism to capture all of the languages spoken across the state, and certainly the diversity within the Asian American community is reflected across many other immigrant communities as well. I think that is a large barrier, and many immigrant communities, if not political at home, are certainly small p politicized in the current environment. And I think it's not for lack of want, it's the opportunities that we're we're presenting, and as Senator Bailey shared, the tools that we're providing to the community to make sure that we're mitigating all of those other systemic barriers and hurdles as well. And I think that's not succinct, so thank you.
Yeah, no, that was pretty good. Do you have anything? Senator Liu?
Thank you, Mr. Chairman. Thank you, Amy, for joining us. I have no idea what she said, Mr. Chairman, because I just walked in. I tried to get back here in time to hear her testimony, but whatever the hell she said, I agree with.
It was very eloquent, rest assured.
Thank you, Senator Liu. Amy, thank you very much. Next up, our penultimate testifier. Yes, round of applause. Is Elena Cantillo from the New York Immigration Coalition.
Good afternoon. Chairman Myrie and members of the Senate Committee on Elections, thank you so much for holding this hearing and allowing me the opportunity to testify. My name is Elena Pilar Cantillo, and I'm the Senior Director of Advocacy at the New York Immigration Coalition. On behalf of the NYIC and our 200 nonprofit organizational members across the state who work with immigrant New Yorkers, we want to affirm our strong support of the New York Voting Rights Act. As previously stated, the need for these protections date back to the federal government's enactment of the Voting Rights Act of 1965 in response to the Jim Crow laws and widespread voter disenfranchisement and intimidation. This act gave the government the ability to actually enforce the 14th and 15th Amendments with one of the main tools that has been spoken to at length, including being preclearance. The preclearance requirement prohibited certain jurisdictions from implementing any changes that might affect voter access, and this included the pre-approval from the U.S. Attorney General and the U.S. District Courts to ensure that these changes did not allow for discrimination around certain key communities. 9 states in the South were covered in their entirety, with select counties in other states that included New York State's own Bronx, Kings, and New York counties. The U.S. Supreme Court decision in 2013 largely invalidated the preclearance requirement, and as a result, many states have begun sustaining assaults on voting rights, specifically targeting non-white voters. Some of these changes have also been highlighted here, and they include changes to poll site hours and locations, eliminating early voting opportunities, gerrymandering, and introducing unnecessary and restrictive ID requirements. Enforcement of the Voting Rights Act depends on the willingness of the federal government to secure these rights to our citizens, and it's made clear that the Trump administration has not made a conscious decision to do so. Although mostly associated with the southern states, voter suppression and disenfranchisement also has a long history in our state of New York, and now it is up to each state to defend the voting rights of its residents. Several states have passed their own version of the Voting Rights Act, and New York must follow and do the same. The New York Voting Rights Act would be the strongest and most comprehensive state law of the Voting Rights Act to date, and will establish New Yorkers as a national leader on voting rights. Some of the key components of the law include the legal tools to fight voter suppression or dilute voters' access to protections or clear protections in federal law, the vital preclearance program, the ability for nonprofits and other legal providers to bring cases against voter discrimination, the language access component, and protections against voter intimidation and deception. The New York Voting Rights Act is a vital and necessary tool to safeguard the right to vote all across New York and must be passed this year. We thank you for your time and look forward to submitting our testimony after this, and I'm happy to follow up with any questions.
Thank you very much for your testimony, and thank you again for your patience and the work. We look forward to reviewing your submitted testimony.
And we look forward to partnering with you in the future. Thank you.
Thank you. Y'all know what to do. All right, and last but certainly not least, Maya Contreras from the All Women's Progress Party.
Good afternoon.
Good afternoon.
Let me adjust my mic here. Thank you. Thank you, Senator Kavanaugh. Thank you, Senator Liu. Thank you, Chairman Myrie, for having this critical hearing on voting rights. My name is Maya Contreras. I am a voting rights advocate and co-founder of the nonpartisan, not-for-profit All Women's Progress Policy Center. I respectfully submit this following testimony in strong support of the New York Voting Rights Act. My work as a voting rights advocate is to bring awareness to the obstacles that eligible voters and marginalized groups face when attempting to cast their ballot here in New York State and throughout the U.S. Accessing the ballot box for Black, Latinx, AAPI, Native, trans, and disabled voters has become increasingly challenging. And as Representative John Lewis stated, the Supreme Court struck a dagger into the heart of the Voting Rights Act. Protections were narrowed after raising the threshold for liability under Section 2 of the VRA and dismantling Section 5 preclearance, all together in the Supreme Court Shelby County decision. The absence of Section 5 preclearance has made it difficult to identify harmful voting changes before they take effect, because states and localities are no longer required to notify federal officials of the changes to voting laws. The absence of Section 5 have led to the proliferation of voter suppression, voter disenfranchisement, and voter intimidation. I want to bluntly state the purpose of the deployment of voter suppression tactics is not only to deny eligible voters and marginalized groups access to the ballot box, but to keep them from attaining any real political power here in our democracy. And I applaud the immense progress that has been made in New York State this past year on voting rights with our new Senate Democratic majority. And I'm so thrilled to see that a series of bills to establish early voting, no excuse absentee voting, modernize and expanded voter registration, to name a few, but without the protections of the VRA on the federal level. Our state desperately needs a New York Voting Rights Act that Senator Myrie introduced for consideration. Many think of New York as a liberal bastion where voter suppression could never happen. But only a few miles from where I sit right now, voter intimidation took place in Troy, New York, when county Republican officials threatened to share voting registration records with U.S. immigration to check if undocumented immigrants were illegally registering to vote. That would amount to voter fraud. Voter fraud is almost non-existent in the United States. As my friends at the Brennan Center for Justice have stated, it is more likely that an American will be struck by lightning than to impersonate someone at the polls. And I will add also to vote undocumented. What does exist is voter dilution, voter suppression, voter disenfranchisement, voter intimidation, partisan and racial gerrymandering, disinformation, lack of investment in voter mobilization, and a perceived lack of power or importance as a voter. With the passage of the NYVRA, New York State would join California and Washington in having our own state Voting Rights Act that would build upon the comprehensive framework of the Voting Rights Act of 1965. The NYVRA would both address a wide variety of overlooked infringements on the right to vote and put in place protections that would be among the strongest in the country. New York could send a powerful signal to the rest of the United States that illustrates that we value the voices of all our eligible voters equally, and that we fought to encourage and to protect their right to participate, not only to pick their elected officials, but to have a real say in critical policies that affect their lives and the most vulnerable in New York. As Senate Majority Leader Andrea Stewart-Cousins said, we need more voices in our democracy, not fewer. The New York Voting Rights Act would be the most robust and comprehensive state voting rights act to date and would firmly showcase the Empire State as a leader in promoting and protecting political participation. I could hope or wish that we would soon have a U.S. Congress that will champion voting rights and restore and expand upon the Voting Rights Act of 1965. But we in New York State cannot wait for that exalted day. The conservative majority on the Supreme Court have indicated to us with their 2013 Shelby v. Holder decision that they have little interest in reversing their decision to restore the most effective civil rights law in the history of our country. Since the gutting of the Voting Rights Act, we have witnessed as a nation 1,688 polling closures in mostly Black and Latinx communities. 16 million voters were purged between the federal elections of 2014 and 2016. This does not include a record 6.1 million Americans who were forbidden to vote because of felony disenfranchisement, nor the 1/3 of all people with disabilities who reported having difficulty accessing the polls because of a lack of accessibility. In strict voter ID states, trans women and men face barriers because of difficulties obtaining IDs that are accepted or dealing with bias because of misunderstandings of law when it comes to their gender. These are just a few examples of why we desperately need an effective civil rights laws, more of them, not less of them. I, on behalf of All Women's Progress Policy Center, urge the passage of the New York Voting Rights Act without delay. I thank you for your time.
Thank you very much for your patience and for your testimony. We look forward to working with you as well. There we go. But before we conclude, there's one more round of applause to give. Without these following people, this hearing would not be possible. A lot of the work that we do would not be possible. So I want to thank the staff, enter their names into the record. So I'd like to thank Mariah Pickard, Cyan Laguerre, Nick Tischler, Edleen Jacquette, Jonathan Tim, our central staff, Andrew Golston, Liz Robbins, and all of our tech people who can't be seen on the camera, but who are making this happen. Thank you very much. And also to, obviously, the millions of viewers at home. Thank you for sticking with us this morning, and that concludes.
Wait. One more applause.
Okay.
For our chairman extraordinaire. Pardon the intrusion.
No, thank you. Thank you, Senator Liu. We now conclude the public hearing on the New York Voting Rights Act. Thank you.